Chris is Senior Counsel at Hogan Lovells, founder and board president of the Future of Privacy Forum, founding editor of the Practicing Law Institute's first legal treatise on privacy and information security law, and all in all, a pioneer in the privacy field. Chris's work has covered many of the foremost issues in the privacy world, including cloud computing, social media, the Internet of Things, connected cars, online tracking, and cross-border data transfers. We're grateful to Chris for joining us today to talk about his career, his experience in the privacy field, and his thoughts on the future of privacy law. Thanks for joining us, Chris.
John, thanks for having me. Good to see you.
Good to see you too. So I will begin at the beginning, which is to ask what drew you to a career in the law, and what was your path to becoming an attorney in the privacy field today?
Okay, great. I love telling this story. It's my I call it my doing well by doing good story, because much of the opportunities that I've had in privacy law have resulted from pro bono cases or community involvement, and that'll become apparent as we talk. So I'm one of the rare native Washingtonians. I'm a fourth generation native Washingtonian. In fact, if you can see some artwork behind me, they're all by my great-grandfather, who was an artist in Washington. Wow. In the late 1900s and early 20th century. These are paintings of Rock Creek Park and the Potomac River and so forth. That's my mother's side of the family. On my father's side of the family, they're all lawyers. And my grandfather in particular, I have was president of the DC Bar, and I have a picture in my office at Hogan Lovells, the Bench and Bar of Washington, DC, 1907. It's 200 lawyers in total. It includes all the judges. And not surprisingly, given the times, there are no women and there are no minorities. And I think my grandfather may have been the only Jew in the group. And interestingly, Frank Hogan of Hogan Hartson, then Hogan Lovells, is pictured, as is my grandfather. And so when I joined Hogan Lovells, Wolf and Hogan were back together again. And so I guess I was destined to be a lawyer. My brother's a lawyer as well. And I majored in political science at Bowdoin College. Always thought I would be a lawyer, and had my mind set on clerking for a federal judge after law school, which I was able to do here in Washington for Aubrey Robinson, who was one of the very first African-American federal judges. He was on the Superior Court here in DC for a year, and then was appointed by Lyndon Johnson to the federal bench. And he was a spectacular judge to work for, had an amazing array of cases. First year was a criminal docket, the second year was a civil docket, and I could tell you war stories from that period, but we don't have all day. So I'll just fast forward to after my clerkship, I went to work for Arnold and Porter and was a generalist litigator. And frankly, for the first 15 years of my career, from 1980 to about 1995, I was a generalist litigator. And I used to joke that I thought my tombstone would read, "He died with his options open," because I was dealing with a variety of matters, all interesting, I thought, including antitrust and international trade, even some international law. I got to go to El Salvador in a case before the World Court involving the mining of the harbors in Nicaragua. So lots of really interesting cases with great mentors. But the time came in about 1990, I guess, and I've had an interest in music for most of my life. I played the trumpet for 30 years. I just participated in the CBS. It wasn't a competition, but it was a thing where they asked people to submit videos of you playing taps on Memorial Day. And so I stood outside in my front porch and did that. But it took a while to get my chops back to what they were before. So I played the trumpet. I was interested in music. And I ended up on the board of the Nashville Symphony Orchestra here in Washington. And I found myself in the basement of the Kennedy Center. This is about 1990, calling donors. And sitting next to me was the general counsel of MCI, which some of the interns may not recall, but some of the older lawyers on the call will remember that it was the company that challenged AT&T's monopoly, in addition to the federal government challenge to its monopoly. on long distance, back when you had to pay for long distance, which is also a quaint artifact. Anyway, I got to know the general counsel, and what you do as a partner in a law firm is ask for business, and I guess I, as delicately as I could, asked for business. And he gave me a small matter involving the airplane hangar for the private jets at Dulles, having nothing to do with privacy or technology or anything. But I guess I handled that case satisfactorily, because the next case I had was a dispute over the development of some of the backbone to the internet. And the case was pending in federal court in San Jose. The case went on for several years, the discovery and the back and forth and the motions practice. And the trial lasted, it was a jury trial, lasted 3 months. And many of the experts were experts in the development of the internet. And we won that case. I don't normally talk about cases that I lost, so we won that case. And I came back to Washington, this is about 1993 or 4, and I said, I think this internet is going to turn into something. It was before there was any commercial, really, application of the internet. Nobody had email accounts. Nobody was on the web. Really, maybe a very few tech-savvy people were. In any event, I dubbed myself an internet lawyer and did what I could to learn about it. I don't have a technical background, an engineering background, but I, learned as much as I could and wrote and spoke about it. Which is, what you do. You dub yourself an expert, then you go out and hawk your abilities and your services. And so, happily, the Washington Post engaged me in a case involving the Church of Scientology. It was a copyright case. The Post was reporting on a dispute between a disgruntled ex-member of the church who had published the scriptures, and the Washington Post simply reported on that. And quoted small amounts of the scriptures, and the Church of Scientology sued for copyright infringement. It was kind of a slam dunk. We were able to argue fair use and the fact that it was the newspaper doing it for a public interest purpose convinced the federal judge in Alexandria to go our way. That led to some other cases. I had some domain name cases and trademark cases. And then, my community involvement got me over to the Human Rights Campaign, which is the LGBTQ group here in Washington, a nationwide group. And the former executive director of EPIC, Mark Rotenberg's brother, worked there. And I've not really met Mark, I guess, to that point. I met him in the cocktail line, and we chatted a bit. So the next thing I know, this is a longer story than you probably wanted, but
no, please.
It kind of tells the story of serendipity and being smart enough to be lucky and knowing when you have these opportunities. So the next thing I know, I got a call from Mark. I told him that I was a litigator in the technology space. He had had a case involving a gay sailor in Honolulu who was being kicked out of the Navy because he had sent an email around on his AOL account soliciting toys for the children of his shipmates. This is the McVey versus Cohen case. And he had used a fanciful username on his email account, which was BYSRCH. And his commanding officer thought that was Boy Search, probably was Boy Search. And he engaged a JAG officer and a JAG paralegal, basically as the judge who ruled on our case that we brought later ruled was a search and destroy mission against Tim McVey. He had the unfortunate name of Tim McVey at the time. That was not a good name to have. And the JAG paralegal went to AOL, called up the operator and said falsely that they had a fax from someone using that username. You could use your AOL account to send faxes at the time. And they just wanted to confirm that it was Tim McVey. And the operator blithely looked it up and said, oh, yes, that's who it is. And they said, well, could you send us attestation to that effect? And they did. And so we sued, alleging a violation of the Electronic Communications Privacy Act, because Tim McVey, when he signed up for AOL, had transmitted his personal information electronically. The U.S. government was accessing that information without a warrant or a subpoena as required under the Stored Communications Act. And AOL well, it may not have been violating the law. It certainly was violating its terms of use and its contract with its customers. And so we went into federal court. The night before we went into court, we settled with AOL. They were smart enough to reach a confidential settlement with Tim McVey. But we sued, and the Navy fought this case, which was interesting. It was in the Clinton administration. We wouldn't have thought that they would have fought so hard, but they did. And as I said, we had a great judge, Stanley Sporkin, who was the former general counsel of the SEC and of the CIA. We actually didn't think that that was going to bode well for us, but it did. His law clerk ended up being Dan Soloff, who of course is one of the preeminent scholars today on privacy. Back then, he was a brand new law clerk to a federal judge. So we had a really lucky draw. And the opinion that they wrote was great. And I'm getting to the denouement here to answer your question, because the Washington Post wrote an article about the case. It was the first time that the government had tried to kick out somebody under don't ask, don't tell, and they'd been unsuccessful because of a legal challenge. So it made, a section, front page under the fold treatment. One of my neighbors here in town said, I really like what you did in that case. I'm a consultant to AT&T. I know they're looking for a privacy lawyer. Can I recommend you? Ironically, AT&T, because I had started this journey with MCI, its nemesis. In any event, I got hired by AT&T to do a boatload of privacy work. And as you said in the introduction, I then set forth to help organize a treatise for the Practicing Law Institute and do what you do to try to accentuate your bona fides, write and speak on the subject. And that's what launched me into privacy. So I'll stop there and let you ask some more questions. And I promise not to filibuster.
No, that was wonderful. And I'm probably going to ask you now for some more war stories. So I hope you don't mind. I'm curious, and you've already spoken about this a bit, but looking back over your career to date, what projects or cases stand out to you as being the most compelling personally or momentous or formative?
So, I remember a cartoon in the New Yorker that showed and by the way, I ended up being a partner in a law firm from 1987 to 2016 when I retired and became senior counsel, which now I just do pro bono matters, things that I want to do. But there was a New Yorker cartoon showing a partner talking to a young associate. And he said, look, we've got to do all this anti-bono if you want to do the pro bono. And so, I did my share of quote unquote anti-bono, representing corporate interests over the years. The good thing about privacy law, and we can talk a bit about this, is that most of the work that I did, except in the very early years when clients said, I don't want to comply with this privacy thing, do whatever you can to get me out of it. Most companies want to do the right thing. They may not end up doing it, but certainly in the Office of General Counsel, the objective is to do the right thing. And so I spent a lot of my time advising companies on how to do that. But frankly, the most rewarding work that I've done over the years is representing individuals typically in pro bono matters. Rarely have individuals called me, although I had a couple individual libel and defamation cases where I represented the publisher, but it was in fact the author and the author's reputation that was on the line. But in addition to Tim McVey, I represented an Army. This is kind of a funny story because I got a call out of the blue from somebody who said that they were an Army lieutenant, they were gay, they were Mormon, and they were Republican. And I jokingly said, I don't know what your problem is, sir, but we'll just plead insanity. Because it seemed like a number of inconsistencies there. In fact, his name was Steve May, and he was an Army lieutenant who had served under Don't Ask, Don't Tell without telling and with no occasion at all to implicate that. Had been discharged and then went into politics in Arizona. And one of his fellow Republicans, I guess you had to be a Republican to be successful in politics in Arizona at the time, one of his fellow Republicans on the floor of the legislature attacked the gay spouses of government employees. They were talking about domestic partner benefits. And at that point, Steve May came out on the floor of the Arizona legislature, and that was published in a local newspaper. The government or the military then called him back into service. And his commanding officer, I guess these commanding officers don't have a lot to do. They sit around thinking about how they can ruin people's lives by drumming them out of the military. His commanding officer read it in the paper, and on the basis of that, tried to get him kicked out. We weren't as successful with the adjudicating body there, which was an Army board in 29 Palms, California. But again, serendipity plays a big role. I went to a wedding in Cape Cod and was seated next to the president's chief of staff, John Podesta. This was in 2000. And, you know, we were making chit chat. I told him about the case, and he did what you'd expect him to do, which is, you know, when you're done, and if you haven't gotten the result you wanted, come see me, but I can't do anything now, which was like, go away, don't bother me, is how I took it. And so the 2000 election occurred, Supreme Court ruling, I should say, and went to a Christmas party that year, and there was John Podesta, and it's like across the room, he said, how's that case of yours? How did that turn out? And I said, well, we're not done, but you are. And he said, well, come see me at the White House next week. And so I did, and we negotiated a settlement, and Lieutenant May was able to serve out his term without being kicked out. Again, sorry to take so long to tell that story, but it was gratifying to be able to preserve his reputation and his integrity, and he was devoted to the military and didn't think it was fair, and it wasn't. I also represented Valerie Plame, who some may recall was the spy, the CIA spy, who the White House outed in retaliation for her husband writing an article about there not being yellow cake in Africa. Again, it was gratifying to be able to help that individual. But I should say that, you know, corporations are not faceless bodies. I don't believe they have individual rights like the Supreme Court did in Citizens United, but there are people working there, and I've always valued the relationships I've had with our clients and with people. And, you know, a lot of that led to, we'll get to this, I suspect, my founding the Future of Privacy Forum, which now has about 250 corporate participants in addition to consumer advocates and academics.
Well, so that's a perfect segue. I was indeed going to ask you about the Future of Privacy Forum. Could you talk a little bit about what led to the formation of FPF and how its work has progressed over the past 10, 15 years? I forget exactly when.
13 now, 2008 we were founded. So I mentioned AT&T, and I got to know the general counsel, who happened to be situated here in Washington, even though the company was based elsewhere. And he engaged me to do what I called astroturf lobbying or ankle biting lobbying. It was, they were almost fictitious entities that coalitions that would, you know, take out newspaper ads on things like net neutrality and, you know, whatever spot issue of the day it was. But they, you know, in all honesty, they weren't real. They were perfectly legal, but they, you know, they weren't compelling. They weren't involving individuals, and they also involved issues that went away typically very quickly. Net neutrality didn't necessarily, but other issues did. And so we were having lunch one day, and I was developing my privacy law career at this point in the 2000s, and I said, you know, like the internet thing in the 90s, this privacy thing I think has a future, and you know, I think it would bode well for AT&T to underwrite a group that would be nonpartisan and neutral and recognize the value of the use of data, but also recognize the importance of privacy. And in fact, the use of that data probably wouldn't be possible unless people had trust in it or trust in the companies using it. And so he agreed to underwrite the Future of Privacy Forum for the first couple of years entirely, which was amazing. I was still practicing law, so I did it part-time, but the first thing I did was engage Jules Polonetsky, who had been Chief Privacy Officer at AOL and at DoubleClick. He was the Consumer Affairs Commissioner for the city of New York, had been a legislator in New York State, and just an amazing guy. He doesn't have a technical background, but you wouldn't know it because he has, you know, deep technical knowledge and an amazing network of friends. But in the first, I would say 3 or 4 years, it was just the two of us. And we were kind of ad hocing. We had a few handful of issues. But, as we grew, companies and policymakers recognized the value of the work we were doing. We were producing white papers and so forth. And AT&T said, we're going to wean you off of our support, so you better get financial support from others. So we created a whole staff and, got a separate set of offices. And we've really grown from there. We have almost 40 people on our staff now full time. We have offices in Brussels and in Tel Aviv and in Singapore. We've expanded our work to, I always worry about mission creep, but we've expanded our work to so many different issues. And it really pairs nicely with the speech that I give frequently to groups of privacy lawyers, which is that privacy specialization is really the way of the future. When I started, you could be a privacy generalist and handle virtually anything. But now there are so many specializations, whether it's health privacy or connected cars or AI and the Internet of Things, cross-border transfers. There are just so many areas where you could go very deep and make that your entire career. Sort of the analog is to the 40 Act dealing with securities law. There are securities lawyers that have spent their whole career on just the 40s Act. And so FBF kind of parallels what's going on in the practice of privacy law in private firms, I think.
So in keeping with the name of the organization, I'm curious for your thoughts about the future of privacy. What gives you hope about the future of privacy law and privacy, and what keeps you awake at night? What worries you?
So what gives me hope is that finally, lawmakers are waking up and recognizing the need for comprehensive privacy legislation. And at the same time, I think companies are looking forward to specific guidance on what they can and can't do. Because I've represented quite a few companies that have gone into the FTC and found themselves under consent decrees, which are incredibly onerous and incredibly expensive. Those 180-day reports that they have to submit through accounting firms or consulting firms, take a big chunk of time. It would be a lot easier if they had known going in what was and was not permitted. So it gives me hope that we've got state laws now. I had thought maybe we would have had a privacy law in this Congress. I kind of doubt it now, given how difficult it is for them to do most anything. But I still have hope. Obviously Europe has led the way with the GDPR and with the developments there. But what gives me pause is what's given anybody who's looked at this over the years pause, and that's the invisibility of what's going on and the potential for terribly pernicious uses of data. I think that's going to continue to be a problem. And related to all of this, of course, are the cybersecurity issues. You can't have privacy without cybersecurity. And if we're going to continue to have these enormous cybersecurity attacks and breaches, it's going to be hard to contain privacy.
So if someone were to hop in a time machine and go back and tell you 20 years ago what the current state of the internet and privacy law is today, would you be surprised? Would you be disappointed? Would you be confused? What is your sense of the development of this field over time?
So I'm surprised that it's as complex as it is, and that it's developed as quickly as it has. When I was at Hogan as a partner, we used to brag about how big we were when we had 20 lawyers. Well, now I think there are well over 100 lawyers within the firm doing this, and we're not alone. There are lots of other firms, and you look at privacy offices and general counsel's offices within companies. It's become an enormous venture, and that surprised me. I didn't think it would be this big this fast. Although I used to analogize privacy to environmental law, and that developed slowly until it developed quickly. And we, after 1970 with the Clean Water and Clean Air Act, it became a real profession for people and a real focus, and every company recognized the need to pay attention to environmental laws. And we're getting to that point with privacy, I think. So that gives me hope. You know, what makes me lose sleep at night, this may be answering your earlier question, is the unknown use of data and you know, the proliferation of bad actors. So those are the two things mainly that keep me up at night.
So you've also done quite a bit of work on hate speech online and the spread of lies and conspiracy theories and bigotry, violent speech, and so forth. You co-authored a book about this in 2013. There you go.
There it is. Yep. There it is.
So a lot's happened since 2013 when it comes to online speech and platform governance, and I'm curious generally for your thoughts about the future of content moderation and platform governance.
So I'm pretty pessimistic here, and I was pessimistic in the book as well. And interesting, a lot of what we said in the book still pertains. We could probably just write a revised version rather than a whole new book. But you know, I've always been concerned that not enough attention has been given this. When we first met, let me back up and say that my involvement was started and has been almost through the Anti-Defamation League, which is how old is it now? 111-year-old civil rights organization. You know, back in the 1980s, they were focused on bulletin boards of hate, where people used to put telephones in a cradle and they could send faxes to each other and organize meetings of hate groups. So they've always been working on this, but in 1995, I started an internet task force for the Anti-Defamation League and have chaired that effort throughout. We now have a Center for Technology and Society in Palo Alto with a full-time staff of both policy people and engineers who are working with the companies. But when we first got the companies involved, this was probably in the early 2000s. They would agree to meet only on the condition that Chatham House rules would apply, and that you know, we could never publicly attribute anything to them, or even the fact that they were there. We almost had to meet down dark alleys in a darkened room, so no one would know that they participated. We've come a long way from that. At least they are now out in the open talking about these issues. And they're all wanting to take credit for doing the right thing. They really aren't yet, even though Facebook has like 50,000 moderators, believe it or not, around the world. And it's almost impossible to train them to do an effective job. But last year, the Anti-Defamation League organized, I'm trying to think of the name of the campaign, it'll come to me, organized a campaign against Facebook, inviting advertisers to pause their advertising on Facebook because of the bad job that Facebook had been doing in moderating hate speech. We had no idea how many people would sign up. 1,000 advertising companies signed up as part of this campaign. No Place for Hate, I think was the name of it. And in any event, you know, it's a terrible problem. Hate speech online inhibits people who are minorities from using the internet. It drives them off of the internet. It attacks them. It causes psychological harm. But it also leads to real-world attacks. I mean, certainly we saw January 6th organized online. We've seen any number of attacks on minorities organized online. And when we see these mass shootings and go back and look at the social media history of the shooters, you've seen that they participated in conversations online with like-minded haters. So it's ubiquitous, it's viral, it's a terrible thing.
So this provides another great segue. Of course, a lot of work has been done, especially over the past decade, led by advocates of color, to incorporate racial and social justice into privacy work and to underscore that privacy harms fall hardest on persons of color, and to argue that privacy and social justice are in many ways part of the same struggle. So I'm curious for your thoughts on how the privacy field still needs to change to meet this challenge.
Well, it does, and I think if you look at the leadership in the privacy field, it's distinctly white, with some few exceptions. And so I think there needs to be real efforts at both recruiting and training people of color into this field, so that we can have the perspective of various people on what the problems are. It brings to mind an app that was developed by the city of Boston. You may be familiar with this, to deal with potholes. Mm-hmm. And the idea was that the people could use this app to record potholes. It may have even been able to sense driving over potholes. I don't know how sophisticated it was. But what they didn't really realize is that, people, this was early in the days of iPhones. People with iPhones and apps from their app store tended to be affluent, tended to be white, tended to live in, more affluent neighborhoods of Boston. And so not surprisingly, that app reported potholes on Beacon Street and, around the Boston Common and not in South Boston or in Roxy. That's just, one example. There's been some really good scholarship on this. It's something that, the Future Privacy Forum actually has had some workshops on that very issue. And I'm happy to say that we have a board that it has pretty good diversity. We could do better, of course, but we've made that a real effort.
So I wanted to ask specifically about the Federal Trade Commission. You've done, of course, a lot of work before the FTC, and a lot of folks in the field, including not a few at Epic, are hoping that with the appointment of Lena Khan and then a third commissioner to come, that we might be in for a sea change at the FTC and an era of sort of increased enforcement and clarity in unfair and deceptive authority and data privacy. So I'm curious, are you hopeful in that regard, or what are your expectations from the new FTC?
So every time I've had hopes like that, they've been shot down. I could recite numerous commissioners and chairs who've come on board, and I thought, they're going to get really aggressive, and they all feel constrained by the statute and by the court's interpretation of the statute, fairly cramped interpretation of the statute. They've got plenty of authority to go out and investigate, and they can impose consent decrees. But what really hurts companies is the financial fine that they suffer from the FTC, and the FTC is forbidden from assessing a fine in the first instance. They can only do it after a company has violated the first consent decree. Most of them do, by the way, so it's not a problem. But it's still a two-step, which shouldn't be there. The statute really ought to be amended. And ideally, the FTC should become a DPA, should be a privacy commissioner. When I've been at numerous privacy DPA meetings around the world, as Epic, I know. And while the other DPAs are courteous to the FTC commissioners, they're not treated on the same level. They just aren't. And until they have the same standing, same stature, I don't think they will be treated that way, or have the effects of a DPA.
Right. Do you think that's a role that the FTC is best suited to play, or that's something a new agency, an independent DPA, should be tasked with if Congress takes up the issue?
I haven't thought a lot about that. The FTC is well equipped to do it, but maybe a clean slate would be not a bad way to go.
So I guess I'll offer a final question, and I think we'll wrap up then, which is, what would be your advice for young attorneys who are interested in privacy law, or folks who are considering going into the law and interested in privacy and cybersecurity?
Well, the great thing about, as I mentioned, the great thing about privacy law now is there's so many opportunities and so many different avenues that one could go down, both in private industry as well as government and civil society. way more than existed 10 or 20 years ago. And so there are lots of opportunities. You almost can't go wrong. I've talked to a lot of young lawyers about their first or second job, and they're agonizing over what to take. And my advice always has been, do a great job, embrace what you're doing with enormous energy and enthusiasm. Take advantage of the people that you meet. I don't mean that in a pernicious way, but get to know them and maintain those relationships. You never know where they will lead. And looking back on my career, a 40-year career at this point, what I can say is that some of the best things that happened to me by accident, but they were really happy accidents that led to a really satisfying career.
Well, on that note, I think we'll wrap up. Chris, thanks so much for taking the time out.